Hey guys, this is Joe Russo at the Granite Law Group. We do catastrophic injury all the way to simple motor vehicle collisions in New Hampshire and Massachusetts. And I want to do a quick video with you to discuss aggravation of a pre-existing condition. Now, this always comes up as one of the defenses when it comes time for the insurance company to try to negotiate a claim. Most insurance adjusters are under the impression, and it's a false impression, it's not true, that if your client or the claimant has a pre-existing condition, then they are not on the hook for any subsequent treatment related to that condition, and that's a complete fallacy. So the way the law works and the way settlement claims should be negotiated is as follows. You want to establish a baseline before the accident took place. So let's say you're experiencing shoulder issues. You're in your late 50s, you played a lot of sports, you have a banged up left shoulder, there's some chronic inflammation, there's some issues. You're treating with an orthopedist, but you see the orthopedist sparingly. There's been no recommendation for surgery, and perhaps you've been referred for physical therapy. It's been effective, and subsequently you're involved in a T-bone collision, and now all of a sudden you have a new MRI that demonstrates that the shoulder joint has tears where it didn't have tears before. The inflammation is more pronounced, and now you are going to require an arthroscopic shoulder surgery. So under those circumstances, when it comes time to negotiate that claim, the insurance adjuster may say, well, this person had shoulder complications before, and we're not going to pay for the shoulder surgery. Well, that's complete nonsense, and that's not going to fly in court. And that point has to be firmly communicated to the insurance adjuster that you're not buying that defense. You don't credit it, and if that's the way they want to play it, we'll just hash it out in litigation. And oftentimes they'll get in line. But you need to be able to build some evidence to show that this was an aggravation, that the shoulder condition in the past got worse as a result of an acute traumatic injury by way of a motor vehicle crash or crash with a truck, motorcycle, what have you. And the way to do that is through expert testimony. Now, in a perfect world, you're going to be able to get the orthopedist that your client has been treating with before and after the collision to draft what's called an expert narrative report on your client's behalf. It's short money. It doesn't cost that much. Obviously, you're not going to have to organize a new independent medical examination because the patient has already been treating with that medical provider throughout this duration of time. And essentially what we would do under the circumstances is reach out to the orthopedist and say, would you be willing to draft a narrative note describing whether or not there's an aggravation in this case, giving us an opinion about what the baseline was before the collision and whether or not the condition has gotten worse. And in the absence of this traumatic injury with the collision, would this patient have required surgery under the circumstances? And sometimes the expert would be willing to draft the report. Other times the expert would say, look, I have a very robust clinical practice. I don't want to get involved in something like this. I know that if I write a report, maybe I'll have to give a deposition down the road. Maybe I'll even have to testify at trial. It's kind of an inconvenience. I don't need the money. That's unfortunate. It's not a death knell to the case. Because what you would be able to do under those circumstances, if you can't get the treating provider, is to go out and retain another orthopedic expert to draft the report. Now, generally speaking, you're going to want to get orthopedic expert that's in your geographical region. because this orthopedic expert is going to need to perform an independent medical examination of your client, do range of motion testing, review the medical records, and examine the patient face-to-face before they draft an expert report. It has to be scheduled by the law firm's office. The expert would have to get paid. Oftentimes for these types of cases, it's a flat fee, and they're going to give an expert report, and they're going to opine on whether or not there was aggravation in this case. Now, which version is better? There's pros and cons to both, okay? The pros with having your treating provider draft an expert narrative report is the following. There's no argument that the person is a hired gun, because the person is been hired by the patient to treat the condition and possibly even perform surgery on the patient. So, there's a pre-existing relationship between the patient and the physician before this case even became a reality. So there's no argument that could be made about bias involved in a situation like that. The downfall with an expert that is a treating provider is ultimately, not only are you asking the provider to draft an opinion about aggravation, you're also asking them to draft an opinion about whether or not there's a permanent injury. And by doing so, effectively, you're asking that expert to critique his or her work as a surgeon. You're asking the expert to say, okay, you performed this arthroscopic shoulder surgery or whatever body part you're dealing with, and let us know whether or not the patient, despite this successful surgery, is experiencing some residual or ongoing symptoms that would cause them to have a permanent injury. And you're actually asking the expert to quantify a percentage of whole person partial impairment. What that means is they are able to do range of motion testing after the surgery when the patient has reached a medical end result, and do range of motion testing thereafter according to American Medical Association guidelines that they typically use for workers' compensation cases. And there's all sorts of algorithms and numbers, and the expert would spit out a percentage that, your shoulder after my surgery is impaired by 10%, which means effectively the whole person is impaired by 4%. These are just hypothetical numbers, of course. And in doing so, you're asking that expert to ostensibly comment on whether or not he did a good job with the surgery. Now, most experts who perform the surgery themselves, most treating experts, are able to put their ego aside and say, despite how good this surgery is, when someone has a traumatic slap tear in their shoulder or what have you, there's always going to be some degree of impairment left in the shoulder. But notwithstanding, when you're dealing with the treating provider, that's something that's taken into consideration that you have to be a little bit wary about. And when it comes to a retained expert, someone that you actually go out and hire, a little bit different in that it's not that expert's work. So, there's no reservations that you may have about the expert giving a low permanent partial impairment rating. But the flip side of that coin is now that expert is going to be open to cross-examination. How much did you get paid? You didn't treat this patient. You were contacted by the lawyer, not the client or not the patient. The lawyer set this up. Have you ever worked with this law firm before? Have you ever worked with this attorney before? How many times have you testified for the plaintiff side versus how many times you testified for the defense side? And there's several different avenues that a good defense attorney could go down in cross-examining a retained expert to challenge their credibility and whether or not they're gilding the lily, or whether or not they're giving a favorable opinion for the person that has paid them several thousands of dollars for their expert opinion. Now, when all is said and done, a jury sorts out all these issues, and if you're not reaching to make a connection on a case, these arguments, these cross-examination points typically will fall flat. If there's objective findings and MRIs demonstrating And if you're able to articulate through that expert, with showing jury visualization of this is where the tear is, you could actually see it. The surgery actually took place. You know, what were the symptoms before? A lot less severe than the ones thereafter the collision. It's really hard to argue that a physician, someone that has their own clinical practice and is just doing some expert work on the side, is going to be willing to just make something up. They never make stuff up, but sometimes they have opinions that are a little bit shaded, being predisposed to one side versus the other. That's natural, but as long as you're not overreaching for the opinions that you're shooting for, everything just kind of shakes itself out. So I wouldn't be wary of dealing with a retained expert, but ultimately I'm always trying to get the treating expert, because any argument about bias just goes right out the window when you have someone like that. So that's my spiel about aggravated pre-existing conditions and about experts in general. If you have any questions about your case, if you have a pre-existing injury and you're dealing with an insurance company and you're hearing those arguments, well, you had this condition before, we can't pay you for all the subsequent care, we'd be happy to chat with you. This is a common insurance defense tactic, and there's plenty of ways to get around a situation like that. So I'm going to leave a link in the comments, and please feel free to reach out to the firm. Happy holidays, Merry Christmas. See you on the next video.